There we go. We'll call the meeting to order. It's 4:03. Certification of open meeting law requirements have been met, so we'll go to adoption of the agenda. Motion? Motion by Karen, second? I'll second it. Dora, second? All in favor of the agenda signify by saying aye. Aye. Opposed? Same sign?
I'm just checking. Sally and Michelle, can you hear us okay?
I can hear you now.
Perfect.
Sally?
There, we don't see your face. Okay, good.
Yep, I know.
Okay. Okay. Motion was carried. So approval of the minutes of the last Human Services Board meeting in May. Any questions? If not, I would look for an approval of the May minutes. Diane? Second? Dora? Okay. Motion and second to the minutes of the prior meeting. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Go on to the report on the Wanik Center Partnership with AdRC.
I'd like to introduce, for those of you who didn't know, Melissa Youngbauer is our new AdRC Services Supervisor. She's been at a few meetings, but she's going to do the report on the next few items.
Good afternoon. I wanted to talk to you about a partnership that we have started with the Wanik Center in Arcadia. And I'm just not sure if everybody is familiar with the Wanik Center, so I'll start by just kind of giving a brief summary of what the Wanik Center is. It's in Arcadia, and it's a premier fitness, recreation, and event center in Arcadia. It opened in January of 2020, so just prior to COVID. So there was a period of time where it was closed to the public, but it is certainly back up and running. It is a state-of-the-art facility. It is attached to the school, the middle school and high school in Arcadia. It also houses the Arcadia Library. So the prior library had been downtown, next to the elementary school, and now the library has been moved. So when we look at the AdRC mission, which is providing quality services and information to the disabled and individuals over 60, looking at what the Wanik Center goals are, which they are goals including providing recreation, fitness, special events, wellness opportunities, programs, and activities to the public. I really felt like it was just kind of a potential partner for doing a lot of the good works that we are doing with the AdRC. I really feel that our missions align. So have had the opportunity to meet with the staff at the Wanik Center and at the Arcadia School District. And they have been very open, actually just very gracious and very open to the idea of partnering with the AdRC. And so we do have, we've actually started with some events at Wanik Center. And so we did have a meet and greet with the public. It was open to the public. That was just last week. And we had a table set up for the AdRC with information about services and programs that we have to offer. That was promoted on the radio and Facebook that we were there. The other thing that we did that day was we had our senior farmers market vouchers that were advertised that we would be there and giving those out that day. So I think.
You want to explain what a farmer's market voucher is?
Sure, sure. Farmers market vouchers are available to individuals, to seniors in Wisconsin that are age 60 and over that meet the 185% of the federal poverty guidelines. So it's a really neat program. Individuals can apply, and if they are income eligible, they receive $25 worth of farmers market vouchers that they can then use at any of the farmers markets that have approved vendors that are approved with the state. Certainly in our county now, we have farmers markets in Whitehall, Arcadia, and Galesville. And so individuals can go to those markets and use those vouchers. So we had that opportunity there that day that individuals could apply and receive those vouchers that same day. We just started, the state allowed AdRCs or the vendors to start giving out the vouchers June 1st. And so we have 172 vouchers that we can give out. Thus far, we've given out 19. So that's a pretty good start. And the state doesn't encourage you to give them all out, day one. So we'll be giving those out throughout the summer and into the fall. Some of the orchards also in our county are also approved vendors. So that's also kind of a neat thing. So it really turned out to be a really neat event. I feel like there were individuals at the Wanik Center that we were able to outreach to and talk to that typically aren't the individuals that we often see. So that was kind of a neat thing. I did also want to let people know about Strong Bodies. It's an evidence-based strength training program that UW Extension and also just the state is encouraging. And so we have been looking to find individuals that are willing to get the certification for Strong Bodies. And so that has kind of been an effort prior to me even starting at the AdRC, and it had proven a little bit challenging. However, we're very encouraged because the Wanik Center has 2 individuals that are on staff there that are willing to become certified. And so right now in 2021, there is only one training that remains. That is in Madison in August. So we have 2 individuals from Wanik that will be trained in that program. And so the goal would be to start offering that program, the Strong Bodies program, hopefully in the fall of 2021. The sessions for the Strong Bodies include progressive weight training, flexibility, and balance activities. And so, again, it's a pretty cool program. I actually met with somebody today from Tri-County who has a mom that lives in the Appleton area. She belongs to 2 different groups in that part of the state. It's such a great program. People really seem to love it. But she gets so much out of it, and it's not only just the exercise and activity, but it's also just the camaraderie that individuals with the group seem to share. So it's that friendship and meeting new friends and meeting new people that is really part of what that program is. Wanted to also let people know about a sip and swipe program. Again, that's started, we had some staff in our department that had been trained in that program prior to me starting at the AdRC. But at Wanik Center, I believe we had 4, if not 5 people that indicated interest in this sip and swipe program. The program goes through the basics of tablet devices, shows people how to use the internet, set up email accounts, download and use apps. So again, we were wanting to know, are there people that are interested in the program? And again, 4 or 5 people expressed an interest, and so we are going to offer that class on June 26th and June 28th. At the Wanik Center. We also have 2 other trainings. So we've been busy. We've got 2 other trainings that we scheduled for this fall. Identity theft is certainly something that is really gotten to be a problem. It is the fastest growing crime for seniors in our state. And so we have an individual coming from the state and doing identity theft training. That's going to be on November 23rd. And we also have a youth in transition training, which is really geared towards youth in our county that someday are going to be transitioning and having needs as an adult. And so what we're finding is that's something that, really parents and the youth need to prepare years for, because it's such an important milestone and something that so many decisions need to be made, and people need to be well informed and educated. So that'll be geared towards youth and parents of children ages 12 and up.
And they're transitioning to the adult system?
Adult system, correct.
As they have some type of disability.
Yes. That's going to be on October 6th. So we're hearing a lot about Wanik Center. We just feel that it is a real fertile ground for AdRC programs and services. One of the things that we will be looking at is exploring options if people would need transportation, busing, or a ride to Arcadia. We certainly would want to be able to help people get there if they are not able to get there themselves. And I think that certainly may be something that people may be interested in. I have talked to some people, even with the Strong Bodies program, that they have expressed, a willingness or interest in travel to Arcadia. Overall, just the long-term plan would be once we experience some success with some of these programs and services, then we have the model. Then I feel that we have something that we can show other areas of our county, some of the neat things that we have been doing, and then we could start hopefully replicating that in some other parts of the county. So, yeah, I think it's a pretty exciting time. I think we're very fortunate to have the Wanik Center interested in just being really open, and really pretty much anything that I've asked them, they've just been very open to that idea of just hosting these events at no cost to us. So it's been really, really nice.
It's hard to believe Melissa's only been in this job for less than 2.5 months, so just a little over 2 months. So she's really hit the ground running. So we don't know if you have any questions. We know you like to get reports on some of the cool things that we've been up to, so that was kind of the purpose of this. But if you have any questions or any input, we'd love to hear them from you.
Yeah, absolutely. If anybody has any questions.
And you don't have to be members to go to these programs?
No, the only exception would be the Strong Bodies program. I do need to work out some of the details about how that would work. There would be a suggested donation, which would be similar to what some of the meal, like the congregate meal sites. It is a suggested donation for that. So it probably would look something like that. But the details of the classes are yet to be worked out. But as far as any of the other programs that I talked about, including the Sip and Swipe or the 2 trainings, there's no cost for that.
And you don't have to be a member.
You don't have to be a member for that. The other thing that I do hope to find out some more information soon is that I have learned that many senior insurances do cover the cost of memberships. I do know that the Wanik Center is able to help people. If you were to bring in a card, they can help explore whether or not your card or your insurance, your supplement would pay for the membership. I hope to get some more information that we could even share with our newsletter regarding the most common insurances. I think that would be helpful to people. Because again, of just promoting the health and wellness that the other programs that they have currently available. Are there any other questions?
Thank you, Melissa.
No. Did she cover, I know she was talking to membership.
Just did number 5. Membership is a different one.
Okay, so then we'll go on to number 6, discussion and action on the ADRC membership.
Do we have any new members?
Yeah, and what that is referring to is we do have one other individual that is interested in becoming a member of the board that would be representing the physical disability category. So at this point, am I able to say the name of the individual? Okay, that's what I should do. Okay. Her name is Paula Henches. She's a retired occupational therapist. She is retired after working quite a few years. I don't know the number of years. I'm actually meeting with her tomorrow morning. But she had been working as an occupational therapist with the Trempealeau County Healthcare Center for many years. She is a trained presenter on the falls prevention program called Stepping on Falls. So I don't know if any of you have heard of that or participated in that program. Stepping on.
Yep.
Mhm. Yeah, it's an evidence-based program that is well recognized in the state that is designed to help prevent falls. It's a really neat program. I had helped Paula when I worked for the healthcare center with that program and had done some of the presenting of that program because it really does go over a lot of different things, including medications, home hazards, a lot of different things. But she is a falls prevention trainer. She is also a guardian of at least one individual that I'm aware of. I think that she would have a lot to add to the council.
Are we ready to put her name forward to the county board for approval?
So the process would be that it would go, if this committee recommends, it would then go to the county board for
Okay.
approval, yeah.
right,
And
so
then
we're-
we'd still have one other vacancy on the ADRC representing the developmental disability population.
Okay.
And we're continuing to look to fill that position as well.
Okay. What was her name?
Her name is Paula Henches.
Okay.
She's a resident of Whitehall.
Okay. So I would move that we approve Paula Henches for a position on the ADRC Advisory Board.
I will second.
Thank you, Michelle.
Okay. Motion by Genie and second by Michelle to approve of Paula Henches, is it? To be on the ADRC membership.
Because then
Board.
I think there's time to get that name to the county board, right? When's our
Yes,
next,
it'll
our meeting
go
is
to
next
the-
week?
If we can get it on the agenda for this month, otherwise it can go in July because the ADRC advisory doesn't meet.
Oh,
until
that's right, we don't
August,
meet
so either
till,
one
yeah,
is fine.
yeah, okay.
Okay. We have a motion and a second, so all those in favor signify by saying aye.
I,
Opposed, same sign. Carried. Okay. Paula would be added on, and then you're, got
It'll go to
another one
county
yet.
board for approval, yeah.
Yeah, right, but you got another one you need to get yet.
We're still looking to fill the last vacancy on the board, again, representing the developmental disability population.
Okay. And we'll go on to number 7, discussion action on congregate nutrition bid process and recommend action.
So last month, you approved re-releasing the RFP for the congregate meal bids. As you recall, last fall, when we did the meal bids, it was in November, right when COVID was starting to really hit hard, and we only received a few bids for that. One was from Boondocks, which this board has expanded from 3 to 5 days. One was from Dove, which they only had one participant in the past, so we've continued to not open that site. And one was from Rainbow in Blair. We also continue to operate the site in the Pine Creek Church on Tuesdays and Thursdays. Again, at this point, because of COVID, the sites have been to pick up the meals, but we just went live with the meals.
June 1st,
June
we
1st.
went Yes,
So with-
dine-in.
So with that, we put out an RFP, because usually we have at least another 3-4 places that throughout the county that provide congregate meal sites. So we released the RFP, we got the bids back, well, we didn't get bids back. We got nothing back. And so, do you have anything you want to add on that?
I guess, yeah, the only thing that I would add would be the ADRC board had met, or the council met last week, and there was just discussion, I would say, regarding just a desire to have more congregate dining in our county. And so at that point, just there was discussion about potential for exploring other options. At this point, my plan is to just kind of get out and start talking to people and see if there are any restaurants or caterers, food trucks, any individuals in our county that may be interested in being a congregate site, or again, a congregate site, it may look different than in a current establishment, so.
And I think we talked a lot about, or at least I brought up the fact that many small restaurants were busy filling out their federal requests for PPP dollars, because those applications had to be in, and I think we talked too about making a 3-year commitment when you don't know if your restaurant's going to make it for 3 years. COVID was responsible for a lot of chaos. And I think our RFPs came at the same time the federal government was asking for, and I think that's not an easy application from the feds to fill out. And I think, Deb, you brought up that even our application is long as well.
The document, the RFP itself listing all the requirements you have to do is long. The forms you have to fill out is pretty simple.
Okay.
But you got to know what you're getting into. And so
It
that
could
is
be a
several
little
pages.
intimidating to somebody of not really familiar with how this all works, I would say.
But we kind of have to have all that language in there according
Right.
to the state.
Right. So I really appreciate your idea of getting out and talking to people. And we love the idea of the food truck, or at least I did, once a month, different places in this county, going to like the parks for an evening. And I know in Osseo, maybe you could do the food truck the night they have music. So it could even be, more opportunity for our seniors to get out and be with other people and do things that are healthy. And
Right. I think there's just a lot of opportunity, a lot of potential. And so I do feel it will require just getting out and hitting the pavement and starting to talk to people.
Okay.
So to be able to do, first of all, a couple of things, to just take a food truck spontaneously and go someplace. The challenge is we've got to collect data on the people that participate. So if you're going to go up to a food truck and it's like, well, here's a form, write down your name, your gender, your age, da-da-da-da. So again, we want to make sure that that's, we find a way to meet those state standards and yet make it convenient for seniors. And I think Melissa's so good at thinking outside the box. ADRC advisory is so engaged in this process. But what we would need from this board that Melissa and I are recommending is that the RFP deadline be held open until 12/31/21, pending the receipt of any additional applications. That way, as Melissa's out talking to people, or the individuals from the ADRC Advisory Committee are out talking, that there would be a means that they could then turn around and submit an application.
Okay, that makes sense. Oh, I just have a quick question. There's another ADRC somewhere that's doing the food truck, right? So we don't need to reinvent the wheel. You could check with them and
Correct.
see how they manage that.
Right,
Okay.
right.
And
There's
I would,
got to be a way to get around it.
yeah, what we just want to do what's best for our seniors and give them an opportunity to have
Right.
some fun and socialize, because it's been
Right.
18 months of no socialization.
Right, right.
And I think some are really scared to come out.
Right.
So,
And I did just want to mention, when we sent out the request for proposal, we did spend a significant amount of time, we did an exhaustive search. Those letters, those requests for proposals were sent to every dining establishment in our county. So all of our communities.
Right.
So even, bars that serve food, golf courses that serve food, all of those establishments, they all received a letter, so all persons had an opportunity to bid. In addition, we did put out information in our shoppers, the 2 shoppers for the county, and in the Trempealeau County Times. So we did try to make it visible, and we made it available to anybody that was interested. I just wanted to make people aware
You
of
could
that.
hook up with the Lions Club. They're doing once a month in Strum at the parking lot of TCC, a brat thing with brats and ice cream and is this the second Monday of the month? Yeah, I think that's when they're doing it,
And that's a Lions Club?
The Oliva Strum Lions. I would move that we keep the RFP open until 12/31/21.
Okay.
So we can talk about it. I just wanted to ask, so if we do that, that means we can't make a decision on anything till after 12/31, so you wouldn't be able to, is that correct? My understanding that you keep.
I guess our intent was as they come in, we could make decisions on it as they come in. Because I think as opportunities do develop, and I think Jeannie's exactly right, COVID has just decimated this industry that we're looking at. The other piece depending on what we can stir up, we have, other than Pine Creek, we have always had a system whereby we contract out for meal sites rather than operate them. I think as Melissa has conversations, we may come and talk to you about choosing to operate perhaps in another site. I'm not recommending that today. I think we want to be able to use the experts out in the field that know how to do this, that are in this business. But that may be an option. Again, we want to be able to serve all seniors in the county and make it convenient. And there's a lot of cool opportunities, but sometimes they materialize, sometimes they don't. So just so you're aware, we may come to you with a request to operate versus contract.
I have a question. If people, you said you have to register and stuff, is this an all-time thing for a person, or do they have to do this every year?
So you mean, you're asking about the frequency of the meals? Yeah.
If you go to a meal site and you register, then you don't have to register every time. Like if you, like when Sunflower used to have a meal site, you would go and you'd register once, and then we'd just write down Dora Jean every day that you came in, and we'd have all your data. So we don't have to redo this. I think annually you need to refill out that form just to update it. But other than that, and so again, if you go to a food truck in Osseo, and then you go to a food truck in Oliva, or something, I mean, I think we have to find out from other counties what they're doing, because again, we don't want to make that, we have to meet that standard for the state, but how do we do it in a way that isn't like bothersome to, and really detrimental to bringing people in, which is the whole goal of it.
Well, it might be the same food truck that goes to different places, because we don't have a ton of them, that I know of. I know that the Panda Plate, what's it called? Panda? They're actually going to open a restaurant in Eau Claire, but I mean, their food truck is often in Osseo by, kind of a block away from Subway, but, and then there's a couple taco food trucks, so I think if you registered with one truck, you'd be good. I mean, that's just my little brainy thought. I have no idea what I'm talking about. But I love that idea. I think it's just so fun. So thank you for thinking outside the norm.
So, okay, Jean, you made a motion on, would you repeat that motion?
I made the motion to leave the RFP open until 12/31/21, and Karen seconded.
Did you second it, Karen? Okay,
And
okay.
we had a little discussion.
And with the intention that as bids came in, we would consider them.
Okay, that's an addition onto your motion, right?
Yeah, I
Okay.
just thought was what we would do.
Yeah. Okay. Everybody understand the motion? All those in favor signify by saying aye.
Aye.
Opposed, same sign? Okay, carried. Here we go.
ADRC day.
One more yet.
Okay.
That's why I'm sitting here.
Discussion and action on AdRC donation.
So you all made a motion several months ago about accepting all donations that come to Human Services. But this one is pretty significant. I'll let Melissa tell you a little bit about it. And we just felt because of the size of the gift, we'd like your approval to accept it. I know it's been kind of covered by the other decision, but I just want to make sure that because of the size of it, we have its own motion.
Sure. So this is good news. I have been contacted by the law firm of Kulig, Mahalik, and Franklin regarding a donation made to the AdRC from Roman Shabilla from Independence, and the donation was $10,000 to Senior Services of Trempealeau County. And then another separate $10,000 donation to the Trempealeau County Meals on Wheels. So again, that's Roman Shabilla from Independence, from his estate.
I make a motion that the AdRC and Human Services accept this money, going to very critical needs.
Would-
And thank you to,
Yes.
you can hear me, thank you. It was very generous of him.
Yeah.
Okay. Would that be for both donations? Okay.
We need a second.
Pardon?
We need a second.
Yes. Yeah, I just wanted to make sure that it was both Okay, I need a second on that motion.
Second that.
Dora Jean, second.
I just want to say, we don't recall ever meeting this individual, but what a generous person. We just couldn't be more appreciative. Again, as Genie said, these are programs where the federal funding continues to dry up, and to be able to provide these resources to help a lot of seniors stay in the community is so vital and so appreciative and so much. We just really want to thank Roman Prisbilla or Shabilla. I'm not sure, they say, some families say it one way and some the other, so I don't want to be insulting. But just really sincere thank you to his family and to him. In heaven.
We don't need we just use a voice vote on that. Yes. All those in favor signify by saying aye.
Aye. Aye.
Opposed, the same sign. Carried. Okay.
John and Wayne, you guys want to come on up to the table?
Chairman? Hello?
Michelle?
Yeah, I was just thinking about, or I'm going to suggest to maybe send the family a thank you for the donation.
Say that again.
Yeah, thank you, Michelle. Melissa's way ahead of you, and she's already rolling on getting that thank you going.
Yeah,
but
we will
thank you.
definitely do that. According to the attorney, they did say that the family is definitely open to, public, a public thank you. So we do have our AdRC newsletter that will come out. It will be the July-August issue, and there is a thank you in that as well. But yes, definitely we'll send them a kind thank you for their generous donation. Thank you.
Yep.
Okay. All right. Thank you, Michelle. And we'll go on to number 9 in the Diversion Supervision Program Report.
So 9 and 10 are listed as separate items, but we may discuss them together. There's a report that you'll get, but there's also, the purpose of this is to discuss the policy. Mr. Seisha has asked to come to this board and address this board on this issue, so I can turn it over to him.
Thank you, Deb. I appreciate that. I appreciate everyone's time this afternoon and your attention. Genie is circulating the current standing
Microphone.
guidelines.
Mm-hmm.
Oh, can you hear me? Okay.
Now we can hear you. Thank
Oh,
you.
you haven't got it on. There you go.
Can
There
you hear
go.
me now?
You're okay there.
Yep,
Better?
you're good.
Okay,
Thanks.
all right. Okay.
Could you read these for Seth, because I don't think Seth
Oh, sure, I will do that. Genie is distributing the current guidelines for diversions in Trempealeau County, and I'll read those for Sally and Michelle's benefit. These guidelines were adopted back in 2017, in December of 2017. Do we need another? Okay, I think we'll be fine. So before I start talking about what the guidelines are and what I think that some appropriate reforms to the guidelines should be, let me just talk to you guys a little bit about what I mean when I say diversion agreements or talk about diversion supervision. So diversion agreements can be one of two things traditionally. A true diversion, which means that a criminal case does not get filed against a prospective defendant, but instead the decision to file a criminal charge is held open for a period of time pending the completion of certain conditions. Or alternatively, and as is kind of generally what we're talking about when we're talking about diversion agreements, they're deferred acceptance of guilty plea type agreements. So what that means is that after a case is filed, say for example a theft, the defendant in that case would agree to enter a plea of guilty or no contest, have the court make all the findings to find that person guilty, but the court would stop short at that point. After making all the findings to accept the guilty plea, the court wouldn't accept or wouldn't enter the judgment of conviction, but instead would keep the case open for a period of time that's determined by a diversion agreement and make that individual, that defendant, subject to conditions of the diversion agreement. There are a number of standard conditions for diversion agreements. Number one is that a person is not to commit any new crimes. Number two, there is a restitution component where restitution applies. Depending on the nature of the offense, they might need to do some type of alcohol and other drug assessment and comply with follow-up. They might need to submit to drug screening to ensure that they're compliant with sobriety conditions. There might be apology letter conditions. Basically, the sky is the limit when it comes to conditions of diversion agreements. They're not appropriate in every case. There are some cases where they're very much not appropriate. For example, if a victim is very steadfastly opposed to a diversion type agreement in a case where the defendant has harmed them in some way, that's not the kind of case that we would push ahead with a diversion agreement for. But for a variety of reasons, now more than ever, there's a need for diversion supervision in the criminal justice program, and there are a few reasons for that. First is that there is a changing attitude in the Department of Corrections in Wisconsin regarding people who are on probation supervision. Often, people who are on supervision are not being supervised at the rate that they were in the past. They're not having to come in to provide urinalyses. They're not having to come in to check on sobriety. Agents are not going out to the house in order to ensure that it's a safe environment for kids or whomever. The degree of supervision is less by Department of Corrections, and even when violations are observed, the agents are less likely to revoke a person's supervision given a particular violation. Why does that matter to diversion supervisions? Well, something that we've, or my office has been doing in the last couple of years to kind of account for this is we'll have a person be placed on community supervision on one count, for example, a misdemeanor count. In a drug case, for example, perhaps they'd be on supervision for a possession of drug paraphernalia misdemeanor. At that same time, we'd be running a concurrent diversion agreement on the felony possession of methamphetamine or possession of illegal drugs offense that would serve two purposes. One, if we're testing that person and they're testing dirty with our diversion supervisor, it gives my office leverage to revoke that agreement, go back before the court for sentencing on that felony count, and impose a different sentence, something that maybe includes probation, but also maybe includes a custodial component to hold them accountable. We don't always do that. We don't revoke agreements at the drop of a hat. But when people who are subject to concurrent diversion supervision and probation supervision are aware of this fact, it makes them more accountable. They're less likely to blow off supervision when they know that there's a real good possibility that if they do that, they're going to be back in front of the court again, regardless of what their agent does. That's based on a motion from my office to get them back into court to revoke that agreement. And we've had a lot of good outcomes with that. We've really provided a strong deterrent against people not taking it seriously. We provided a strong incentive for people to take treatment seriously, and that's a good thing. Also, why would a defendant do this when they're running the risk of kind of coming back before the court for sentencing on another matter that's transactionally related? Well, they do this because they can avoid, in the example I provided with the possession of drugs, possession of drug paraphernalia, they can avoid a felony if they comply with all the conditions of the agreement. The agreement almost always runs for a longer period than the probation supervision. So, for example, if a person's on probation supervision for 2 years on misdemeanors, we'll put them on for 3 years on the felony count. So, a person has incentive to take this type of agreement because they can keep a felony off their record, whether it's their first felony or another felony. They have strong incentive to comply and keep and kind of stay the path of sobriety and staying clean. So it's kind of a complicated way to structure a plea, but it does a lot of good both for accountability and also it reduces. It has a potential certainly to reduce the felony convictions that we're doling out in this county, which I think a lot of people want to give defendants an opportunity to succeed. This gives them an opportunity to succeed over and above what we already have in place through a record expunction, which only goes up till you're 25. So this provides opportunities and accountability. Additionally, how are diversion agreements used? I described that one situation where we have concurrent probation supervision and a diversion agreement. That's not always the case. Sometimes we have agreements sometimes we have diversion supervision for individuals who are low-level offenders. Those are kind of what people think of when they think of diversion agreements. So, a person who maybe got angry. It was a neighborly dispute. Guy got angry and threw a rake through his neighbor's window. No prior criminal history. There might be some way to kind of address this in the community without giving this person a conviction if the victim's on board with some alternative disposition. Sure, those are common. Young offenders, I think everybody wants to give young people an opportunity to succeed rather than saddling them with a conviction out of the gates. Diversion agreements are appropriate for that. Other types of other types of agreements where diversion is appropriate. Sometimes, well, actually, let me turn first to the guidelines that have been handed out to you all. So these guidelines were accepted on December 5th of 2017, and I'll just read through these quickly. So the first is all potential referrals for diversions shall be screened by Justice Unit Supervisor. That's appropriate. That's a task currently done by Wanik. An average of 5 referrals a month will be accepted for an annual total of 60. Screening decisions will be based on the following: no long criminal history, non-assaultive violent misdemeanors, victim okay with the diversion program, low-level drug offenders, no drug dealers. Offender has to be willing to perform restorative justice measures such as community service and/or restitution. Certain felony offenses only if recommended by the referring law enforcement officer. 6 to 12-month program. Referrals to supportive services, low-risk offenders. So those are the guidelines that were adopted at the end of 2017. These guidelines were created by Deb Sukla. They were created by the DHS supervisor without input from my office and without input from the courts. There are a number of ways in which these conditions aren't meeting the needs of the criminal justice system in Trempealeau County. And I think that they came from a good place. I think that at the time, at the end of 2017, many of you will recall it was a rather chaotic time in the Trempealeau County District Attorney's Office. There was a lot of controversy with my predecessor, who was frankly using diversion agreements inappropriately. He was using them in order to, it certainly seemed, and from the perspective of law enforcement, it certainly seemed that he was pushing cases into diversion in order to not have to work the cases in the way that he probably should have. That's what it seemed like to a lot of people, and there may have been some truth to that. I don't know what was in his head and his heart at the time, but I think that's how it looked to a lot of people. There was a need for the board to act at that time. I think that reason for action has changed over time as my office has built trust with our diversion coordinator, as my office has built trust with the court. The need for these types of guidelines have abated, and I would say that at this point they're preventing effective administration of diversion supervision and criminal justice in the county more so than helping. There are. And that's not to say that all these guidelines are inappropriate. I think that generally they're true, or generally they are appropriate. However, in the case that I just described to you that would involve a felony diversion with misdemeanor supervision, that wouldn't fly under these conditions for a variety of reasons.
Say that again?
The hypothetical that I described with a 3-year term on a possession of narcotic drugs or methamphetamine with a 2-year term of probation, it wouldn't work because the guideline calls for only a 6 to 12 month period of diversion. That doesn't give us any time to kind of run a longer tail diversion agreement on a felony offense to kind of run in tandem with a period of supervision on a misdemeanor offense. So our hands are tied. We're not able to do those types of agreements under these current guidelines. Low risk, non-assaultive or violent misdemeanors. That certainly sounds like, I think that non-assaultive and non-violent misdemeanors are appropriate for diversion supervision. However, it's also the case that sometimes offenses like battery or disorderly conduct, which are assaultive or violent, might be appropriate for diversion supervision. And let me tell you why. Dealing with these types of cases, sensitive cases, creates a number of challenges. Often, the types of individuals who are placed on a diversion type agreement for a battery or disorderly conduct are people who've engaged in a battery or disorderly conduct against a family member or potentially a romantic partner. Obviously, these are cases we need to take seriously. I can say that if a victim in a case like that is opposed to a diversion agreement, we're not going to do that agreement. I can tell you that even if I wanted to do a diversion agreement in a case like that where the victim's opposed, our judge wouldn't approve that diversion agreement. Marcy's Law is a constitutional reform that passed relatively recently. It sanctifies victims' rights. There is no way that I, and there is certainly no way that the judge, is going to look a victim in the face and say, we hear you that you don't want this person to be subject to a diversion agreement, but we're going to do it anyway. It's not going to happen. The types of individuals who get put on those agreements are people who, for whatever reason, have the support of their family member. Maybe that defendant has some mental health issues that makes them volatile in the home. Maybe this was a one-off incident later in a marriage, and neither party really wants to see the other saddled with a conviction, but they're taking it seriously, they're engaging in services in the community, and they're taking actions to make sure it doesn't happen again. Those kind of cases are appropriate for diversion supervision. It's a way to, rather than I think that this condition is designed to protect victims' interest. My concern is that by putting the state in a situation where we either have to dismiss the case or push ahead with the case contrary to the victim's wishes, those options go against the victim's interest. The third way here, a diversion agreement that holds a person accountable, kind of puts them on a short leash, requires that they engage in services and programming. That is an appropriate third way to deal with certain assaultive or violent offenses, depending on the facts. And that's my primary concern here. These guidelines strip away discretion where discretion really is needed. There is discretion at just about every level here. There's discretion from the prosecutor, from me or my assistant. There's discretion to not approve or not supervise an agreement from the diversion coordinator, Mr. Opichka, and there's of course the discretion from the victim to approve or disapprove an agreement, and finally the judge has to sign off on any agreement that goes before the court. The judge reads all proposed diversion agreements, and if he doesn't believe that the victim's rights are being protected, if he doesn't think it's appropriate for this particular defendant or this particular set of facts, he'll say so. You know, I've had to answer questions in the past from the judge about why a certain case is appropriate for diversion supervision. If he doesn't feel comfortable with it, he's not going to approve it. So I think that there are checks and balances built in already without these guidelines, and these guidelines limit the court system's ability to provide a useful third way to defendants, something that's not a dismissal and that's not a criminal conviction, but is something else that promotes accountability. It limits our ability to provide that third way in a way that hurts victims and that doesn't adequately meet defendants' needs. There are other situations in victim cases where in exceptional circumstances, diversion type of agreements are appropriate. And that might be when a victim is, for whatever reason, not willing to cooperate in a case. They may be coerced, they may be afraid of retaliation, they may have certain misgivings about their partner or the defendant, whatever their relationship is to them, being involved in the criminal justice system. We need to find a way or it's very helpful to have a way to hold people accountable in situations like that, where we have victims who will be humiliated if they testify, victims who are afraid to testify despite assurances, victims who are committed to not reliving the trauma of what they went through, but still would like to see some accountability. Diversion agreements can be very beneficial in cases like that. I've had many victims thank me for proposing that option, sparing them from testifying, but yet keeping that defendant on supervision for an extended period of time, and requiring that they meet certain criteria. So again, although some of these guidelines for supervision sound very good and they look very good on their face, in practice, they tie the hands of the criminal justice system and are not beneficial. Another circumstance that's kind of that's barred by where a diversion would be barred by these guidelines is a case that involves a large amount of restitution. We've had situations where elderly family members, for example, have been taken advantage of by a grandson or a granddaughter and had money or property stolen from them. This is a situation where often family members just want to see the money repaid. They don't want to see their younger family member who maybe has a substance abuse issue, maybe has some other thing going on in their life. They don't want to see them put through the criminal justice system ringer, but they want to get the money back, and they want that person to comply with certain conditions. A long-term diversion agreement is appropriate for that. We have some people on diversion agreements for 5 years to give them enough time to pay, $50 a month or whatever it is that they can pay back over time. When we say only 6 to 12 months on a diversion agreement, it completely knocks out those large restitution cases and runs against the interests of victims.
Can I ask a question?
Yes, yeah.
Since it looks like the same criteria are on,
That's my report, I'll go through it when John's.
okay, wouldn't it make sense to have a committee of human services, DA, judge, victim witness, maybe Sally Miller?
It's called the CJCC. It's Criminal Justice
Okay,
Coordinating
that
Council.
group to look at developing guidelines for restorative justice, because I know it's like probably been 10 years ago that when I was working for a treatment foster care agency, our building was trashed, and the 2 young men that were responsible for that had a huge amount of restitution to pay. In fact, I just got a check for $11 the other day, so they're on a long-term diversion program to pay back, and they've been working their tails off, to pay all of us. They had a lot of people to pay because it was a huge building, and it wasn't just our office that was trashed.
Yeah, I think, and I wouldn't mind looking at a copy of Deb's report, but there are some counties where the CJCC actively supervises agreements. I think that putting this to the CJCC is something that could be done.
Well, I was thinking of a smaller group, like you, the judge,
Sure.
Wayne, and maybe the victim witness coordinator. I mean, because as a human services supervisor in my past life, I would not always know what are the best cases for diversion because I'm not seeing those people in court. I've done another piece of the work with them. I mean, it was the same thing in juvenile court unless I did a dispositional or a IDA, informal disposition agreement. Then I developed that myself. But this would be different.
I think that could be beneficial. I'm not opposed to kind of advisory guidelines. However, my concern is that we're going to have a situation that falls outside the guidelines where all parties agree that a diversion agreement is appropriate. Sometimes we have people who have substantial criminal histories who are really making an effort to kind of turn things around, and in those situations where all parties kind of agree, including the diversion supervisor and including the judge, cases, those kind of one-off cases, I think that there should be some flexibility built into the system.
Okay. So is there an opportunity if you have a case that doesn't fit any of these guidelines to say, okay, we have this perfect case that I think could be diversion, but it doesn't meet the criteria? How can you introduce flexibility into this is what I'm searching for here.
Sure. I think, I don't think that I think that prior to December of 2017, that these guidelines didn't exist. They were put in place to kind of deal with my predecessor. And I don't think that they're necessary at this point, given the levels of oversight that we have. Given that there's a screening process at the prosecutor, at the victim level, at the diversion supervisor coordinator level, and then finally at the judicial level. I don't think.
Oh, so you're saying let's get rid of these?
I think.
Is that what I'm hearing?
I think that's appropriate at this point.
Okay.
I'm open. I'm certainly open to discussion about best practices. However, I don't. I think that there needs to be flexibility built into the system because no case is exactly the same. There are certainly case types that are on their face ripe for diversion, but once in a while there are cases where a diversion might be appropriate and all parties agree that diversion is appropriate, but that no set of guidelines is really going to encompass. And sometimes time is of the essence in these situations, and kind of waiting until the next CJCC meeting to kind of pitch it to members of the CJCC might not be feasible.
Okay.
So I don't think it's necessary at this point. And looking to what other counties are doing, based on my review of other counties' practices, only Pierce County has the Department of Human Services supervising diversion agreements. So I think that most other counties and most other applications, they're leaving it to the courts. They're leaving it to the prosecutors, defense counsel, victims, and judges to kind of determine what's appropriate for these types of agreements.
Well, isn't that what the prosecutor and the defense attorney do along with victim witness coordinator? Figure out what is going to be the best plan for the defendant? I mean, you have plea agreements all the time and you work these things out, and that's really the forum where it should be done?
Absolutely. Absolutely. I totally agree with that. Those parties are the parties who are in court all day, every day. Well, with the exception of victims, but victim witness, or kind of our victim advocate, or our victim witness person in my office, she's in court every day. She's dealing with victims every day. She will certainly make her voice heard if a diversion agreement's being proposed when it's not appropriate. Frankly, if I'm ever considering, or if I'm ever asked to consider a diversion agreement for a victim case, the first thing I do is reach out to my victim witness coordinator, ask her to reach out to the victim and solicit their input on it. So I guess the point is there's a lot of supervision built into these agreements already, kind of at the level of kind of every actor in the system, and so it's not necessary, given that supervision, to kind of bring it back to another body, and I don't think that's happening in other counties. I don't mean to suggest that I'm not willing to talk about what best practices are, because I am. I very much am wanting to do my job better and kind of make the system work better for everybody. But at this point, kind of given what we've seen, given the response that we've seen from Deb in intervening in some of these agreements, I don't think that it's necessary at this point to kind of continue with these 2017 guidelines. This is really an issue that I could talk about for hours and hours. Maybe I'll just leave it there, and if you all have questions for me, I'm happy to answer them. If anything's not clear, I'm happy to discuss that further. But yes, I don't want to go on for hours, kind of talking about every potential situation where a diversion agreement might be appropriate or might not be appropriate. Because my point is, at the end of the day, no case is exactly the same. Rigid guidelines often cause more harm than good in situations where we're dealing with human beings and human lives, both victims' lives and defendants' lives. If actors can trust the discretion of criminal justice system actors, prosecutors, defense counsel, victim witness coordinators, diversion agreement supervisors, and the judge, the discretion of all those people goes into the formulation and acceptance of these agreements. If we can trust that all of those actors are going to be able to come to a sound result, I don't think that there's a need for formal guidelines.
Do you feel like the victim?
I'm going to have a report, Jeannie, too.
Okay, I just have one more question, because the victim seems to be the bottom line here. If the victim says, this is not good for me,
Yes.
then doesn't happen. But do you get a sense in your work with victims, or maybe the victim witness coordinator knows better, that their decisions to go yay or nay are made not based in fear, or not, they're not being pushed into making a decision that they're not comfortable? Do you feel like every victim is comfortable with the decision they make about yes or no?
I do. There are certainly some situations where I wish that I wish that a victim would be more motivated to testify in a case, but I understand that that the process of being involved in a court or a trial to a jury or a trial to the court, or even just being subject to cross or being made an issue of in motion practice, it's really uncomfortable for certain victims.
Right,
You know,
yeah.
they're
But I just
Yeah.
want to know that you feel like if they say, yes, I agree with this diversion program, that decision is made without pressure, without
Yes.
fear? Okay.
Yeah,
Because that's what would worry me, that victims would be pressured into by a family, if it's a family member or whatever, you know?
Yeah, the types, you know, usually these agreements are like the sort of violent type agreements that get supervised are situations where it's a one-off incident, or maybe a case where a family member has some mental health issues and they needed to call law enforcement that night. Because it was an exigent circumstance or an emergent circumstance, but they didn't necessarily want their loved one to be convicted and put on probation and put in jail.
Okay.
In cases of habitual domestic violence, those aren't cases that we're pursuing diversions on. You know, sometimes I've had to have hard conversations with victims, and where they've recanted statements, and I need to tell them, you know, listen, this is not your partner's first run-in with the criminal justice system. I need to push ahead with this case. This is not appropriate for a diversion for diversion, given his history. We need to push ahead here, you know, and so I think that everyone's very sensitive. Everyone in my office certainly is very sensitive to what's going on the ground in victims' lives.
All right,
Yeah.
you and I could go on forever. but
Yeah, absolutely.
Looks like Sally even wants to say something.
All right.
Well, I was just going to say, the victim decides what justice looks like to them. One size does not fit all. So each victim has to decide what justice looks like. And that's kind of where Marcy's law takes its position. And one of the things that I, you know, this is what I do for a living. I work with victims of all forms of abuse, adult, child, sexual, the whole bit. And they are certainly, there's many factors into the decision-making that victims go through. And when they are discussing with the prosecution, with law enforcement, even with the judge, there's so many moving parts of what's going on in their lives that it's not simple. It's really not simple. And sometimes the best thing this time around may not be the next best thing next time around. It takes victims 7 times to successfully leave an abuser on the average. I do have a question, John. Has the judge ever refused to allow a diversion agreement?
He has. And usually, there's one case that comes to mind where the judge had some questions about the victim's stance in the case and whether there was kind of victim approval, because it was a domestic violence case. We kind of went back. We adjourned that plea hearing, went back, had some additional follow-on conversations with the victim in the case, just to ensure that this is absolutely what she was comfortable with, and she was willing to kind of incorporate that into a revised victim statement in the case. Oh, the reason the judge had concerns was because the original victim impact statement didn't say anything about approving a diversion agreement, and so the judge read that statement, had concerns that we hadn't had the approval of the victim in the case, and he sent it back. So yeah, that's one example of the judge looking at the facts and saying, yeah, this isn't appropriate.
Yeah,
Currently.
in the essence of time, I think we're going to move on. Thank you, John.
Thank you.
So let me provide a little bit of additional information on this whole situation. Before I go into my report that I handed out, understand that in diversion, there's 2 pieces of this. There's the whole part where the DA's office gets a case and makes a decision on how to prosecute the case. That is not the purview of this department nor this board. The other piece of it is the side of it is supervising the cases that have been deemed to go through diversion, through the DA, through the courts, through all of that. And that's what we're really talking about. That's the job that's been assigned to us at this point. And so that's really what we're talking about, is our capacity to do that. It's nothing more or less than just our capacity to do that. We are not experts on what the DA's office or the court should do. So a little bit of history. In 2012, at that time, there was an individual, Pat Bell, I think many of you remember him. He worked for the DA's office. He did half-time diversions, half-time recovery court. The DA at the time, Jerry Marsalik, shared that she no longer wanted that position in her office, primarily because the position the grant was paying for it was expiring in late 2013. So I don't know how this happened, because this happened just before I got here, but my predecessor, Jeff McIntyre, said, we'll take on the position. And then he retired a couple months later. So the other piece that helps fund it as well is some fees. We collect about $10,000 a year in fees in the diversion program. And a half of a caseload has typically been about 50 people to manage. Again, I suppose it depends on the type of cases that you have, but 50's been kind of the number that Pat always said was a good number for a half-time position. So Human Services took that over. I started here July 17th of 2013, and within 4 weeks, less than 4 weeks, I had to bring a budget started in July 17th, 2013, and within less than a month, I had to bring the whole budget for the whole department for 2014 to this board, including how am I going to fund this position that has a grant that's expiring? And so what I did at the time, again, because Judge Damon was a judge at the time and had really impressed upon me how important both the recovery court and the diversion program was. So what I said was that we would apply for a grant, and if the grant didn't go through, we would still have to pay unemployment, because those of you who are watching, or those of you who are here are unfamiliar, counties don't pay unemployment insurance, but when somebody's laid off, we have to pay the full cost of their unemployment. So in the budget, what I put together was that we'd have the fees that come in, and that we also set aside enough of our own levy. I took levy from children and families programs and levy from behavioral health programs to help pay for up to 6 months of if Pat were laid off. As it turns out, we wrote the grant. The grant could be for one program or the other at the time, so we wrote it for recovery court. It paid for 3/4 of Pat's half-time job, so about a little better than a third of his time, and the cost of recovery court. We had to pay the other 25% of the recovery court program. The diversion program, we collect again about $10,000 in fees, and the rest of it we had to pay for out of our levy. I chose to do that as a good partner. The other piece that we do for this program, couple pieces, is the administrative work in terms of not the case management piece of it that Wayne does, but it's tracking, each of them are charged fees, and then tracking, have the fees come in, how much do they owe, receipting, depositing all the fees. That sort of thing. And then related to restitution, I don't know why this has happened, but we've just always done it that way, because counties say that all the time. But for restitution, Wayne does all the work to work with the individual to collect the restitution, and then that comes to our department. We have to receipt and deposit that. We've got to track to make sure how much they've paid of it, and then we have to turn around, and our department cuts a check then to the victim to pay for it. For some reason, I don't know why, there's a percentage, I don't know if it's 10-ish%, something like that, that when you pay, so if you have a diversion and it's $1,000, you have to pay another $100 in fees, and that's always gone to the DA's office. So we do the work, the DA's office has gotten the benefit of it. But at the end of the day, the history is that we've been really good partners in this program and really gone above and beyond to make sure that this program could stay alive and continues to operate. And again, the piece of it that we are invested in, that we have put our effort into, is just the supervision piece of it, not the deciding who gets a diversion, but what cases can we supervise, how many can we supervise. So the report that I handed out to you, I'm going to steal yours temporarily, has the same exact thing that John gave you. On the back side is taking those same exact words and changing it into our format for our policy. I don't know why we never put it in our technical policy format. It's the same exact language. You can adopt it as this policy format. You can make any changes you want. Also attached is the current caseload that we have in as of Friday. I don't know if we got any new ones today, so I'm saying as of Friday. So you have that in front of you as well. I do want to point out, too many papers here, bear with me. Of the case, we have 56 people currently on. We have 7 people that will be done by the end of the month. So we'll be down to 49, but then I assume we'll get a few more cases as well. We also have, if you look at that, I can't find my report. I've got too many papers. Sorry about that. We have 30-some that are on there that are diversions that are in excess of our current policy timeline. Give me a second here. I know it's all right here. Oh, crap. It's in a folder now. I'll never find it. So we have 30-some that are in excess of the 12 months. So it's about 62.5% of our caseload. We also have about 40% of our cases are felonies, that is based on the information that we received from Wayne. I also looked at the information to see, gender-wise, how are we doing? And that's pretty equitable. It's close to 50-50, so I think that's a fair representation of that caseload. Nope, I have different notes on my special paper that clearly must be sitting in my office. But thank God I memorized all these numbers. So, and then we have about 12% of the cases that I say are violent or assaultive, and I only counted domestic violence cases or battery cases. So those I didn't count disorderly conduct. So we are currently operating outside of these guidelines for a variety of reasons. One is, it's the recommendations from the district's attorney's office. Oh, now I find it. It's clipped to a sheet of paper. Good God. Sorry. And part of it is we just haven't really evaluated this program. The report you have is probably the most significant evaluation this program has had, at least for the supervision side of it, in 8 years since I've been here. The average length of the current caseload, the average number of months is 23.96, so the average is about 24 months. So that's our current situation that we have. And so I'd like to talk through a few points. John is correct in that the policy was created in response to a difficult time we were having with the district attorney's office at that time. I think the policy is still, and I'll go into some points why I think it's still a good policy for the supervision. Again, the DA's office can do diversions for cases. We just don't have the capacity to supervise them. That's the only difference. We don't have it isn't appropriate for us to tell the district attorney's office what cases to have a diversion or not. So we did create it in response to a difficult situation, but in the same way, if a staff person showed up dressed with atrocious attire and I said, oh Lord, we need a dress code, I hope that never happens, by the way, I would write a good dress code. I'd write one that's in response to all staff that would be appropriate for all the work that we do for the foreseeable future. And I think that's what we prepared here. I looked at the length of time issue, and I've done some research myself, and in the performance standards and goals for pretrial diversion intervention put together by the National Association of Pretrial Services Agencies, they recommend in here, for most participants, 6 months to 1 year is sufficient time that change should have occurred to make a reasonable prediction to the participant's potential for law-abiding behavior. Only in extraordinary circumstances should a participant be required to engage in diversion intervention for a longer period of time than that. For example, if it is to pay restitution, there are other vehicles in the court system that would allow for that. Not everybody that pays restitution, to my knowledge, is on diversion. Not everybody on diversion pays restitution. think that's correct, isn't it?
Deb, just, I don't want to, I want to let you talk, but are you conflating the terms diversion and deferred acceptance of guilty plea? I'm concerned that what you're looking at relates exclusively to true diversions and not what is kind of colloquially referred to in the criminal justice system as diversions, which include deferred acceptance of guilty plea type agreements.
Well, if your question is if I'm an attorney and know the courts of law or the fine points of law, I don't.
Well, I just want to make sure that we're being clear about, if
I
you're
have always been
presenting
told
this
this is a
information.
diversion program, and that's what we're supervising. Again, if you want to do other types of legal things with the cases, that's totally your purview. But I understood these were diversion cases. That's what I've always been told they are. So that's the research that I've done. If we're doing a different thing than that, that's something I was unaware of in the last 8 years.
We're doing the same types of supervision that we've always done. And in Trempealeau County, traditionally, that type of supervision has been post-plea, deferred acceptance of guilty plea type agreements. And I'm concerned that we're kind of, you're comparing apples to oranges here by looking at true diversion agreements where a person hasn't even been charged with an offense against cases where we're post-plea. So
I also looked at the standards for the state of Wisconsin has the treatment alternatives and diversion program has standards for diversion. They have the pre-plea and the post. Okay, the pre and the post. And so I really looked at the standards for the post, and they were very similar to that as well, if that's the distinction. The number of cases, I don't think that's been an issue. That was an issue when we wrote this policy. That really hasn't been an issue for us. We have seen some growth in the program, but only because people are on it longer periods of time. I did do a quick review of just some counties online, and I printed out all of them that I found, was probably about 10 of them. Many of them stick to the 6 to 18 month timeline. There are a few that go up to 24 months. I couldn't find any counties that go in excess of 24 months, and they only did up to 24 months for felonies. That's what other counties have done. That is another piece that I found in the research. In terms of the violent, the issue of people that have violent backgrounds, the TAD program, pull that up here. Again, the standards that the TAD program has put out, the law says, statute 169.95, for a county to be eligible to run this through a TAD program, for example, and this is, it says that the program establishes eligibility criteria for a person's participation. The criteria shall specify that a violent offender is not eligible to participate in the program. Now, this isn't funded by TAD at this point, but it certainly does provide a standard that shows that we're not having violent offenders would be a good thing to keep on. And as far as felonies and misdemeanors, our research study done in 2019 showed that about of the counties that participated, there were some rural, some urban, about 200 some counties participated. Over 60% of them only took misdemeanors in a diversion program. So again, that's where that came from as well. Lord, I have too many papers. This looks like my desk. I think one of the points is that we really should be looking at is the goal of, what is the goal of the diversion program? And again, our goal is to serve cases that are more appropriate to be supervised by human services. If it's a mechanism for the court system to be able to manage a case for whatever court-related purposes, that probably isn't appropriate to be supervised by human services in our current program. So again, I would recommend that the policy as it's written makes sense. If there are cases outside of that, that is certainly the DA's office has an option to operate that program with as much funding as we received in the first place, which is the fees, and find the rest of it on your own. But that's, again, I've done some research. I've really looked at what makes most sense for our department, and that is really all that this body can really talk about. We really can't say what cases John or should or should not refer to diversion, or what type of tool he uses to create a diversion type of case. So that's, again, the policy's in front of you if you want to approve it, change it, whatever you want to do.
If there was another body to provide supervision,
Oh, that's my other point. Thank you.
who would it be?
Yeah,
Because I was just looking at Chippewa County, their diversion program is 12 to 24 months.
yeah.
Well,
And I'll just say that in the research, when you read about what these standards say, they're very clear in this manual, they're very clear in the National Prosecutors Association description of diversion, that there should be written guidelines that are approved by a body that includes the district attorney, the courts, probation and parole, the party that does the supervision of the cases. All we have in writing for individuals right now is the court ordered, which includes what their job is to do and what we're going to do in terms of the conditions that they have to do, and then our guidelines. Those are the only ones that exist. So if what we have right now isn't adequate, that's certainly, well, I would kind of agree with that. But I would also say that the CJCC should really be developing some really robust guidelines, because one of the things that's really coming up is equity and inclusion these days. And are all of our cases following, like, who is eligible to be in the program? And are we enrolling people who are eligible? Do we have, are there any ways that we are missing out on equity and inclusion? And again, because that's such a sensitive issue these days, having standards that are written in advance and that we follow in all cases. And I know John says he needs flexibility, but it's very interesting that from the state of Wisconsin, the standards that they put out, the standards put out by this National Association of Pretrial Services Agencies, and even in the National Prosecutor's Handbook, or I can tell you what it is, I can look it up in a second here. They all say there should be some description of the program, and it should be followed, and it should be monitored, and there should be regular evaluation. So my recommendation, if this body does anything, is to take this issue to the CJCC and have them really create that, because I think the piece that, again, we're kind of on the very end of it, and it's hard for us to respond what our job should be on the very end of it when there isn't a true description of what the whole thing is.
So does probation and parole supervise some diversion programs in other areas of the state?
they do not.
So it all falls in human services?
Actually, it rarely falls on human services.
It's in the DA's office?
In most counties, the vast majority of counties, it's in the DA's office.
So there's a social worker or someone, professional, who's in the DA's office who supervises all the people that are put on diversion programs?
Exactly. That's the majority of cases statewide, or the majority of offices statewide. The diversion supervisions happen under, in the same way that the victim witness coordinator is a position that's funded partially by grant, partially by my office. The diversion coordinator is in most cases, or most counties throughout the state, a similar position under the DA's office umbrella. And I think that really I don't see a reason why that would be not appropriate here in Trempealeau County. I think it would kind of relieve some stress for Deb, who I know has been very interested in involving herself in the types of cases that Wayne is supervising. I think that it would alleviate some of the tensions that Deb is alluding to today.
So maybe what is the acronym for that group?
CJCC.
CJCC maybe this should go back. And maybe this position needs to go back to the DA's office, like when Pat Bell was there, because I don't feel confident in approving anything today, because there's so many moving parts here.
Absolutely.
Sally's got some
Chair?
comments, yeah.
Yes.
Yes.
First of all, do we have any idea how many of these are domestic violence cases that we're referring to? Because I keep hearing reference to it. So at one point, we did have a domestic violence diversion court. We had a program that was disbanded in the middle of a blizzard by a motion by the former district attorney who wanted to create the diversion program aspect of it. At that time, we had, basically it was the equivalent of the recovery court, monthly accountability. There was a team that met prior to the DV court and would review progress, review violations of restraining orders, review any additional input from the victims. This did come before the Criminal Justice Coordinating Committee last month. We're meeting again in a few weeks. It was put on the agenda for next month's meeting, so this actually is something that has already started to move into that pipeline. But I have asked a few times about restoring the DV court, so perhaps it's time to look at some of those diversion courts that I've been bringing up to the judge and other players in the system, and then seeing where some of those go, and maybe that does create that that relief of the is something appropriate or not, because I absolutely do not believe that a violent offender should be in there, and the idea that they only do it once is undiluted bullshit. They don't only do it once, they only get caught once, or they only get reported once. They always have a system. Abuse is a course of conduct intended to intimidate and manipulate, and it doesn't just happen once. It does it slowly over the course of time, and finally escalates to the point where they become violent because they know they can. And the victim then is put in, the burden of resolution is put on the victim to either be the generous, forgiving person and allow it to go to diversion, or to be the one that is somehow responsible for creating a complete wipeout of the victimizer's life because, they're not agreeing to it. It's an impossible situation for a victim to really find the justice that is there that keeps them safe, and that should always be the goal of what we do, is to keep victims of abuse safe as they try to find the safe path out of the abusive, dangerous situation. One
Sally?
thought too is,
Oh, I'm sorry.
well, yes, I'm finished. The other thing is I get concerned about the notion that we blame alcohol and drugs for abuse. Plenty of people get so drunk that they can't feel their face and they don't beat the crap out of the people they love. Abuse is about power and control. It's about controlling somebody and using fear and intimidation to do it. And if restoring the DV court is how we deal with some of these cases that are being sent for diversion, then perhaps that's the pathway we need to go. Maybe we need to look at a mental health court. Maybe we need to look at a family court. There's a whole lot of options out there that create those avenues that would have their own individual grants that would be administered by whoever's managing those courts. But yes, that's definitely something that should probably come before the Criminal Justice Coordinating Committee.
I think that's a really good idea, and I'm looking through the offenses on these 56 cases, and I only see one that says DV.
There's two. There's one that's battery/DV.
Oh, battery
Sometimes
DC.
domestic violence is an enhancer. Yeah.
There's one that's certain.
I see battery/DC, disorderly conduct.
You got it right here. Deb.
I only see one DV, unless I'm missing it.
I think that,
It's something slash.
Yeah, it's
We
battery/DC.
need to take caution here to
Yeah, I don't
not
see it.
sort
So.
this out into something it's not.
Right.
Because there's a lot of people served probably by this program, and what do I know? But who don't fall into that category, and I don't want them to get lost in this conversation.
Right. I would
At the top of
love,
the second list, it's domestic, which is domestic.
Yeah.
oh, DC Dom?
Yeah.
Oh, okay. So there's two cases, but I would love to have this conversation be larger than this group because there are so many things to consider. And I would totally support your idea of the different kinds of court. I mean, Eau Claire County's got like, I don't know how many different kinds. I think, and that's really the route this Trempealeau County needs to take. I don't feel, I think this is just bigger than me right now, and
John, if you were to take over the supervision, do you have resources to do that?
well, I don't at the moment. I don't have a position funded, and that's part of the reason why, Deb, I've been trying to talk to you about the TAD grant applications, why I requested to kind of be put on the agenda tonight, because I've found that those conversations were less than fruitful. And so I wanted to bring to this body's attention the fact that there is a need for expanded diversion supervision from the district attorney's office. There is a need for other departments apart from Department of Human Services to participate in the TAD grant application. And I've been trying to strike up those conversations, but haven't had a lot of luck until recently when I filed an open records request to get some documents to facilitate that conversation.
I think you are falsely portraying the situation, but you did file an open record request, that's true.
I did, and the records are there if anybody else wants to review them. But that's part of why I'm here. It's about resources. We need to think of ways that are creative, that fund useful programs in this county, whether it be a bond supervision program that our judges talk quite a bit about, or whether it be an expanded diversion DAGP type supervision program that I think that there's a need for in this county to address victims' needs, to address defendants' needs. There's an expanded need for all these services, and I think that conversation.
I have an idea here, and I think Sally will love this idea. The county's getting $5 million. We maybe need to look at using some of that money to develop a mental health court, a domestic violence court, because these are all people who really suffered in the last 18 months through COVID. Abuse increased, alcohol, drug and other alcohol abuse skyrocketed. And I really wanted to use that money to help the people that were impacted the most from COVID. So I don't know how to do that, but I think we need to really look at better serving the people in this county.
Regarding the TAD application, so again, we got a position, there was no money, we wrote the grant, we got it funded, we used our own resources to fund 3/4 of it. We have a full-time person doing it now, but we fund 1/4 of their position because it's required by law to have a match. The diversion program, again, we are using our own resources that we took from children and families and from behavioral health that I believe this committee would, if the program were to move, would want to continue to reinvest those funds in children and behavioral health services. We provide all the administrative work. We continue to provide the administrative work for the restitution program, where the benefit goes to the district attorney's office. We've been sincerely a great player in this program. The open record request that Mr. Sasha wanted was evidence of what we had submitted for the TAD application. I did provide that. I was told that was insufficient because it didn't include the diversion program. The diversion program is not funded by the TAD grant at all. And so that was what that issue was about. So we've been a great partner. We've written it. If somebody else wants to help write it, I think that's a great thing. It's been kind of a nightmare writing these grants. Wayne was part of the last go-around. So having other parties doing that, the only decision this body can make on that issue number 11, which we're kind of jumping to as well, is not that Human Services should write the grant. The only decision because that's really, the TAD grant is overseen by the CJCC. So the only decision this body can make is if Human Services were to not participate in the TAD grant, or if we were to not participate in the diversion program. You can't say we want Human Services to write it, or Human Services to, the only thing you can say is we don't want Human Services involved. That would be the only decision this body can make. So you've got 3 issues open, Mr. Chair. I don't know where you want to go with this.
And I don't know if we've kind of folded in the collaboration discussion, but kind of on that issue, I've requested from Human Services, Deb specifically, for on a number of occasions, copies of agreements between the county and testing service providers. One particular agency in the county who's historically provided testing services for drug and alcohol abuse to the recovery court. The reason I've requested that, the reason I requested it years ago, was because there's been renewed interest in pursuing a bond monitoring program in the county that would entail testing for ongoing sobriety, testing for drug abuse. Unfortunately, despite a handful of requests formal and informal, both email and verbal. Those documents weren't forthcoming, and so about a month ago, I had to.
There was no
I had to-
record submitted years ago, to my knowledge. I did receive 2 email requests for it from John. I was told in the whole hallway that if I didn't provide those soon, there would be an open record request for him, and that is what he submitted 40 minutes later.
And that was a month after my first formal request, and so
I think we're kind of going off track here.
Okay, well, there's just one other issue. I was given an invoice for the provision of those contracts by Ms. Sukla in the amount of $111.17 for 4.75 hours of labor to retrieve those documents. I think I question whether it took 4.75 hours to retrieve a copy of a couple contracts. And just looking, if anyone's interested, there is an advisory letter from the Department of Justice on what can be collected for open records requests. It provides in quite great detail the limits of billing for fees, and I don't believe that a person making approximately $24 an hour was necessary to provide me with copies of these documents. I think more to the point, it's not appropriate for Deb to provide or to submit an invoice to my office for $117 for something that should be freely available to the court, to myself, to the CJCC and others. So for those reasons.
That issue isn't really on the agenda today, Mr. Chair. I don't know if you really
No,
want this
no,
discussed. It's really
I think
inappropriate.
we've gone quite a ways with this, and I think we thank you, John, for the supervision program report, and we'll go on to see what.
Well, I think the question is, does anybody want to, do you want to take any action on the policy?
That's where I'm going.
Okay.
That's what I want to find out from the committee, if they want to take any action on the diversion supervision policy. In the essence of time, I think we've discussed this for quite some time, and so I'm looking for some answers on that.
I don't feel
Policy.
comfortable moving on that. I think it needs to go back through the,
So I'd be looking for,
CC, why can't I remember that acronym?
CJCC.
CJCC. I was just looking here, TAD grants were increased $7.2 million.
Well, they're pending
Right.
the approval of the budget by the legislature and the governor. So once that's all done, then those TAD applications will be
Right,
out,
so that's a hefty increase.
assuming it's approved.
Right. Cross our fingers. But I really would like to see, I mean, because I've thought of a lot of different things while I've been sitting here, like the supervisor of the diversion program maybe doesn't need to be in human services, should go back to the DA's office like Pat Bell was back in the day. It makes more sense to be there, but that's all something that I think is a bigger conversation than today. So I'm not ready to make any decision on this
Well,
policy.
I would look for some motion then to table it or whatever.
I would make a motion to table this discussion and Sally, you said some of this discussion is coming up next month on your criminal justice meeting?
It actually was started at last month's meeting.
Okay.
Middle of May, there was a meeting, and this conversation began then, so it was directed to be put on the agenda for next month.
Okay, yeah, I would make a motion to table this. And
That's
have
number 10, that's a diversion supervision policy you're talking about, right?
I'm talking about, yeah,
Okay. So
not the
you-
report. We already heard
I'm
the report.
looking- You made a motion to table it till next month, or?
Well, until, and not necessarily till next month, but until
Okay.
after we hear more from the, yeah, my God, I cannot get that imprinted in my brain. Tell me what the words stand for, then I'll remember it.
Justice Coordinator.
Criminal Justice Coordinated, okay.
Table it till such time that,
Till we feel like we have more, looking at different, because I've started to thinking of all kinds of different things today in this discussion. I really appreciate this discussion.
so you put a motion out there to do what?
To table this discussion until further
Till further,
notice.
okay. Second to that? Rick? Okay. All those in favor of tabling the diversion supervision policy till a later date?
Yes, he wants to make a comment.
Go ahead.
The comment that I would like to make is that this shows that the system that we have and operate under is not working to perfection. And we need to coordinate on a county level these programs so we don't have the infighting and the bickering between departments. And the only way you're going to get that to be resolved is to get the power brokers of this county board to agree to put money where money is needed, not to their pet projects. If it is the courts, the seniors, doesn't make any difference who it is. Those plays have to be thought about and resolved, or it'll be this way for 20 years. Thank you.
I agree.
Absolutely.
Thanks, Rick.
Yeah, I think your word needs is really an important point. And what are the real needs?
We do have a strategic plan, which we haven't looked at since Dick Miller left. It might be wise to bring that up again. There's a lot of stuff. I mean, that's neither here nor there, but it just came to my mind. We spent a lot of time on a strategic plan that sits on a shelf somewhere. And I've talked to John about revisiting that, so. Because our priorities and needs were addressed in that. Okay.
Okay, well,
Did we have a vote?
for the time, yeah, I'm going to get it. Okay,
I
so
was losing track.
all those in favor of tabling this diversion supervision policy, it's been motion and seconded. All those in favor signify by saying aye.
Aye.
Both same sign? Okay, we'll go on to number 11 with the TAD grant application oversight.
That has been discussed
Mr. Chair?
somewhat already.
Yes.
Yes, Sally.
Mr. Chair?
Yeah, go ahead.
Yeah, I have a family commitment that I'm going to have to step out in about 10 minutes, so I just want to let you know.
And I have to leave at 6 as well, so I gotta take care of my horses. There's probably out of water.
I have a birthday party for a
Oh, that's
child.
way more fun than cleaning a barn.
I don't, what action are you recommending on this, John?
I think that I've kind of raised my concerns and points regarding collaboration on this going forward. I don't think we need to discuss it any further.
Okay.
Does this department, does this board need information on how we have collaborated or not collaborated with other departments? This conversation might make it sound less than that, but I think we've put our money where our mouth is. We've done a lot of work in collaboratively, so I just want to make sure that we've done that. What you need.
Personally, I'm aware that we've done a lot of great collaborating. I don't need any more, anything to show me all the stuff we've done. What I am interested in, if we're going to continue to talk about this, is I need more information on the TAC grant and what all it serves, and this whatever they are, CJCC. I don't know the inner workings of what those are responsible for. I do know I'm concerned about losing some of the core of the diversion that I think that these guidelines addressed. And I'm not, while I think that we may have other needs in the county, and we should probably address those, what those might be, but I don't want to lose sight of what we had going on. So that's the information I need, is more of the base information about those different kinds of things, if we're going to continue to discuss them.
If you Google TAG.
I already did.
There's a ton of stuff.
Yep. I want to know
Criminal
about
Justice
Trump.
Coordinating Committee has the judge, it has players from the entire criminal justice system as well as others. So it's already on the agenda for next month. The conversation's already been brought up there, so.
When do you meet?
No, I don't remember the specific date. It's like the second.
That's all right, John will give it to me, don't worry.
Yeah.
He's
Yeah.
looking it up right now.
I am.
So do we need action on this TAD grant application? Is that something we have to address today?
No action.
Okay.
Yes.
That
So we're
was
done.
requested to be on the
Okay.
agenda by Mr. Sessions.
No, I think I just wanted to kind of bring it to this body's attention that that's something that needs to happen. I think that historically it's been addressed only by Deb, and I think that there are many other willing parties, myself and the judge included, who want to be a part of this application, who need information in order to do that, and I think that there's the county will be best served by having a variety of voices from different parts of the system participating in this grant application. And so that's, I wanted it on the calendar because I think it's an important conversation to have. Historically, it's something that's only been done by DHS, Deb particularly. She shouldn't have to do that on her own. And I think that the county would be better served if a bunch of people are collaborating on this rather than just one entity alone. And so,
For the record, I've never chased anybody away that's wanted to do it in the past. I think there's more interest this year than there's been in the past, but I've never chased anybody away.
we're here and we want to help.
Okay, so there will not be any action on the TAD grant. So we'll move on to personnel report.
Oops, sorry.
Personnel report, we have interviews coming up next week for 3 positions. We do have 1 vacancy that came open this past week. Chris Service, who has been our nutrition coordinator and nutrition and transportation coordinator, will be leaving us. She's found another position, and we are going to miss Chris like crazy. She's been here for 27 years. So it is a loss to us, but I think she's excited about her next venture, so that's a good thing for Chris.
Is it retirement, I hope?
No,
Darn.
no. The finance report here.
You can just email me.
I should have it, but
For you.
I've got a lot of correspondence with
and,
the last one in May, but,
Sam, do you want to give this to Rick?
or not the next one.
The finance report that you have in front of you is through the first quarter. We are hanging on in the black by less than 1%. It has been a tough year in many ways in that we've had some pretty expensive placements at Winnebago that have gone on, and so that has really set us back. We'd look like we're doing perhaps a little bit better, but that's we're hoping to continue to stay in the black, but this is going to be a tough year for us. It started out tough, and I think it's going to continue in that path. So that is the financial report. Next month, you'll have through May. And the next meeting is July 12th.
It is July 12th? Okay, the next meeting is going to be July 12th. So at this time, we'll adjourn the meeting at 5:55.
Thanks, everybody.
And if you want brats, there's the brat stand in Strong.